case of Ronald Jeffrey Prible versus Bobby Lumpkin, Director of Texas Department of Criminal Justice, et al. And gentlemen, forgive me if I mispronounce your name. We hear first from Ari Cuenin, OAG, and then James Rytting. Mr. Cuenin, is that right?
Yes, Judge Dennis. Thank you.
Thank you.
May it please the court. Mr. Prible needed the jury to believe two unbelievable stories. First, that Nilda Tirado, who didn't like Mr. Prible, started a sexual affair with him in her own home at 4 a.m. within steps of her fiance and her 3 sleeping children. Then, secondly, after the 4 a.m. sex, Mr. Prible left, and some unidentified unknown person snuck into the house and had killed everybody there by about 6 a.m. the very same morning in the scope of about 2 hours, tops.
It wasn't started an affair that he says, though, is it? I thought his statement was that it's already existing. You meant starting a particular encounter.
Thank you, Judge.
Is that right? Am I wrong?
It's a really important way of thinking about what he says happened. I said sexual affair, right? The sex was the first and only time 2 hours before she was killed. And his story was that after lying to police twice about what was going on the morning of these killings, he comes up with this story that, I was having a secret affair with Ms. Nilda Tirado. But that, in the district court's characterization, I think kind of misses the mark in that from Judge Ellison's standpoint, he kind of saw that as volunteering or admitting to this affair. Well, it only happens after he's lied about it twice. Maybe it'd be helpful to unpack.
Well, I didn't mean to get you off track. Go on with your...
Does the record, on that point, does the record reflect that he said that the first time they had a sexual encounter was that night?
It does. It's State's Exhibit 102. That would be his second written police statement. But I don't mind being off track at all. This is incredibly important.
Okay, so to that point, let me ask you a sort of a broad conceptual question about how procedural default works with 2254E2. Because your brief argues it this way, that Judge Ellison erred by having an evidentiary hearing to expand the record, and that E2's requirements were not fulfilled. And so I get that. Those are arguments as to the Ring of Informants Brady claim, as to the DNA Brady claim, and then there's separate arguments as to the Messiah claim. Then you argue about procedural default. So could you just tell me, I've read Williams versus Taylor, and I'm sure I could read lots more on that, but just from your perspective, what is the relationship between 2254E2, which governs when a district court shall not hold an evidentiary hearing in a habeas case, and I take it the older judge-made doctrine of procedural default?
Thank you, Judge Duncan. I think I'm thinking of it, I think if I understand the question, in similar terms as well, because we read cases like Williams and cases that come after it to indicate that when Congress wrote 2254E2, that's a requirement that sits on top of anything else that we say about the underlying merits of a claim or whether it can get into federal court. It's a standalone requirement. And I think the Fifth Circuit, in an analogous situation, it's not exactly the same, but the opinion did mention E2. It's, I believe, the Johnson case from 2006 that talks about the second or successive bar for bringing successive habeas petitions. And there's a similar understanding of what Congress intended in EDPA, which is to raise the bar on petitioners. And it does apply separately from the underlying claims or what cause you try to show to overcome the default. So the way that would apply here is that the CCA in 2011 did take the extraordinary step of ordering the state habeas trial court to conduct a full evidentiary hearing, and ordered that trial court to determine whether Mr. Prible had exercised reasonable diligence in pursuing his claim. And Mr. Prible had his opportunity to make that record. And as a result, there were findings that led to the conclusion that the claim did not meet the requirements to proceed as a successive writ in state court. In other words, an abuse of the writ. But we know from cases applying abuse of the writ doctrine that you use the same cause and prejudice standard to overcome an abuse of the writ, just as you do to proceed on undefaulted claims. It's the same standard.
Yeah, I think that's generally how I understand it. The reason I asked was I wanted to understand from your brief whether you thought we had to reach the E2 question first as a sort of a threshold matter, or whether we could just decide it on procedural default or something. I just was trying to understand the order of decision. And the other reason I ask is because Judge Ellison's very lengthy opinion, which I have read, does not address whether the E2, as I understand it, as I read it, doesn't address the, hey, is there an E2 threshold met here? In other words, did he fail to develop the claim? And if he did he meet it? I don't fully understand why that is, because obviously, I think it's fair to say that from Judge Ellison's perspective, the development of the factual record during the evidentiary hearing was critical to his finding in favor of Mr. Prible on the merits.
I think, Judge Duncan, I think that's a fair characterization of what Judge Ellison did. There were a couple of parts in that question. I want to address both parts. So one part of it is sort of where in the record, or why does the opinion from Judge Ellison look the way that it does, where there's no explicit discussion of E2? So I didn't try this case in district court, but as I understand, he allowed, the E2 argument had been raised over and over again in trial proceedings, and at some point, Judge Ellison had a bench conference, essentially ruled from the bench, this case is going to an evidentiary hearing, and then we were off to the races from there. So, from that standpoint, it is an error that E2 was not really grappled with by the district court, but does the court need to actually decide that here is a separate question. And it doesn't have to rule for the state. If the court intends to rule for Mr. Prible, on the other hand, the court would have to decide and be the first court to actually hold that E2 can be overcome just by showing procedural default. And that hasn't been the law in 20 years, at least not since Williams. But we also know from Schrierow versus Landrigan in 2007, right, a newer case, where Justice Thomas's opinion in footnote 3 of that opinion notes that the failure to raise that claim in the state proceedings in the manner according to Arizona law in that case was a separate trigger for Section E2. So we have an analogous problem here. But there is another EDPA problem, and that's from Section 2254E1, where, again, the state court had made findings that Mr. Prible's claim was available to him by...
This is on remand from the CCA where you have a hearing, I assume, in front of the state habeas court.
Yes, Judge.
Where the state habeas court says, okay, and I'm paraphrasing, were the ingredients of the ring of informants claim available to his state habeas counsel?
Yes.
So there's that, and you're saying that an E1 presumption of correctness applies to those findings?
It does, and I think there's a footnote in Judge Ellison's opinion where he indicates that he didn't think that there had been controlling precedent on that point, and that's, maybe he was just mistaken or it was in recent flux, but there are cases from this court like Ford versus Davis and Murphy versus Davis that do talk about the factual deference that is owed to implicit and explicit findings, even on procedural issues. So that, this court's not writing on a blank state when it comes to that. There's still those cases.
Let me just ask you one other question about that, and I'm sorry to ask you so many questions, but because procedurally, I just got to get this straight in my head. When the CCA remanded to the state habeas court for an evidentiary hearing on essentially abuse of the writ, cause and prejudice, did the state habeas court make any findings with respect to the DNA evidence, the 72-hour note?
I don't believe that.
It's okay if you don't know.
I could rifle through and I could probably answer, but I want to be accurate. I want to be specific. I don't want to misrepresent the record in any way.
No, yeah.
But I do know that the claims were presented to the court as a package, as they had to be, because if you didn't do that, then you'd have no basis to say you exhausted those claims. So he had to necessarily, or I should say Mr. Prible's new lawyers in his state habeas proceedings had to present the same claims that he's now trying to proceed on now. But this is another important point, which is that one of the witnesses who testified in the state habeas proceedings in 2011 was the state habeas lawyer at the time, Mr. Moore. From the perspective of procedural default and following the rules of state habeas, his testimony is incredibly important in a way that, because he did not testify in the federal evidentiary hearing, no matter how much extra evidence you heap on to this pile where you say, well, this new evidence would have made a difference, unless you put on Mr. Moore to conflict with or contradict in some way by clear and convincing evidence what was developed in state court, Mr. Prible can't meet the necessary threshold here. And even except...
So I see that's interesting that you say that the ring of informants plus the 72-hour note were presented together, because in my mind, help me with this. I mean, I'm sort of keeping them apart because I can see the failure, from your perspective, the failure to develop the factual basis for the ring of informants claim. Because there were so many elements of that were known already. And Moore, as you say, testified a number of things why he didn't do that. The note, though, the McInnes note, how can we say that there was a failure to develop the factual basis of that claim when, quite simply, nobody knew about the note?
Thank you, Judge Duncan. In talking through this and recollecting, I apologize. I was mistaken when I spoke earlier. The 72 hours note was sort of allowed back in federal court on a different basis.
Okay.
I apologize.
No, no need to apologize. I'm just trying to get it straight in my mind. How did that come in then?
So, as I understand, it was part of a work product folder that I'm not sure all the backstory, but at some point, Mr. Prible's current counsel got the judge in district court to look at it in camera and make a call about certain pieces of evidence. We think that's a key example of the sort of diligence that Williams you would have to do under Williams. And if you think your claim is going to depend on work product, for example, to make the argument that Brady entitles you to look at a prosecutor's work product is at least an argument that you should make in state court, and we know it could be made because he ultimately did make that argument to Judge Ellison. As far as the note, we're not making the same argument about the note and E2.
Okay, so you're not. That's important.
Right, so we're not. But
Those things were in an envelope that said attorney-client privilege the whole time? Were they sitting in the open file, sealed like that said attorney-client privilege, or did they get added to that file later?
Thank you, Judge Elrod. I understand your question to be about the letters that some inmates...
I'm sorry, I'm changing topics because this is
it's quite
very
yes.
much, you're talking about open file. I'm just very interested in that.
Absolutely.
Because I know Harris County had an open file, it's Harris County, and had an open file, but that this is these are unusual documents to say attorney-client privilege be sealed. That's not part of...
Well,
and we've had lots of other cases about what did the open file policy actually mean during relevant time periods.
Sure. Right, Thompson versus Davis would be another example. The idea of an open file policy, I think, comes up in Brady cases sometimes, but I think it was...
I'm asking specifically about these documents, though, not generally about Harris County.
Right. There was there was a colloquy at a pretrial hearing about what this prosecutor was going to be turning over to the defense, and one of her assertions was, I'm going to assert work product over notes with my informant. So there's a disconnect at that point. We know from the record at that point that there's not exactly a meeting of the minds.
Do you hear him? Okay.
What should I do?
You need to be louder, and you can scoot a little bit, but don't crowd him.
Okay.
Go ahead.
Sorry. I got a little bit off track.
No, I'm sorry. You were saying, you said that or the office at the time, intended to protect the privilege.
Yes, and as I understand it, they intended to protect the privilege in federal court as well, and I think they'd asked Judge Ellison to look at documents in camera. And we just think as a matter of diligence, under the reading of E2 that Williams adopted, part of that diligence, if one of the claims you're going to make is that there are dealings you don't know about with the informant, by the time it gets to state habeas proceedings, you go to the state court and say, hey, I'm entitled to look at work product documents, notwithstanding Brady, and make that argument in state court. We're not arguing really about whether what should or should not specifically be withheld as work product. It's just about when.
Do they even understand the vast scope, allegedly, of Kelly Siegler's personal involvement in this at the time? Or was it still considered a far-fetched kind of conspiracy theory?
I think it gets right to the.
But
I think that gets right to the heart of the tricky part of this case is that the trial lawyer, this original state habeas lawyer, the state habeas judge, everyone sort of knew that inmates were trying to use information and bargain it away with the state in exchange for benefits. Nobody would know that better than Mr. Prible because he did that. He was a prison informant, and he got Judge Hartman to cut his sentence in half while he was still an inmate in Beaumont. So there's sort of a little conspiracy theory and the grand conspiracy theory. The little version of it would be that inmates were allegedly working together to extract information from Mr. Prible. Well, if you take my friend Mr. Rytting's argument, that's something that would have been known to the defense or available to the defense, certainly at the time of trial or by state habeas. Now, the larger grand version of that theory, that it was a state-led ring of informants where they're feeding them information to manufacture confessions, that didn't exist because he still hasn't proven it, and Judge Ellison found that he did not prove that. Instead, Judge Ellison let Mr. Prible have habeas relief with the little version of
They
the.
don't have to prove that.
Well,
They don't have to actually prove that it happened. They have to prove that evidence was withheld that could have colored that determination. They don't have to actually prove for a factual matter that there was this grand conspiracy or even the little one, do they?
so I think it's a really helpful way of looking at that distinction. The way I think of it is like this. And I think we've kind of moved into the merits of the Brady claim by now, and if it's all right, I'd like to talk about
by all
this.
means, I'll come back and ask you.
Oh, okay, I'm sorry, I just didn't, I didn't want to, okay. So on the merits of Brady, I think the problem is that what we're talking about, the information, the documents, it's not really Brady material, right? It doesn't exculpate in any sense. It doesn't impeach Mr. Beckham, who testified, and the person it supposedly does impeach didn't testify, and there's still no way to wrap that up in the cloak of something that's actually favorable to the defense unless you start reading into it extra things that either didn't happen by the time of trial or were developed 20 years later because of other people's changing stories, or it's the prosecutor's own sort of thoughts and opinions, but the state's never really, you're not expected to help the defense spin inculpatory, incriminating information into something that could somehow exculpate. And it's a really convoluted theory that Mr. Prible has come up with how do you take something that doesn't impeach anybody who actually testified? What do you do with that information? That's still unexplained by the court below and by Mr. Prible. And I think that gets...
You can bring forth witnesses and you can conduct, discovery on it. It seems to me that...
You're right,
that
absolutely.
If Walker said that it was the district attorney, the assistant district attorney doing this, and that she was feeding information to Beckham and to him, or that they got information, that's really relevant to this, to what would otherwise sound like a crazy thing. So that's the problem with this, don't you think? Just fairly.
I had a similar reaction at first too, and it was troubling. But here's what I found after I started looking at that line more, the way, and we're talking really about materiality now, the way this court looks at materiality is like a Strickland claim. And it's not just conceivable, it's got to be a substantial path to actually getting favorable information in front of the jury. Well, let's talk about Mr. Walker. Mr. Walker's story is that Mr. Prible and him were present with these other people who were allegedly in the ring of the informants, but Mr. Prible surely knows who he said what to, what he said, who he talked to, and knew that Mr. Walker was there, knew that these people were allegedly doing these things, taking photos with him. All of this information was known or available to the defense in a way that...
Didn't know who Mr. Walker was. That's the problem, and that's a super common name out in the world and in jail or prison. So, I mean, that's not a... And no, his lawyer wouldn't have thought that was really... They would have thought it was hokey. That's the problem. It was both sounded hokey, and he didn't know who the person was. Both of those things were true at the time.
And so I would say this. Mr. Walker, when we're talking about his lawyer, the reason that Mr. Prible supposedly couldn't find Mr. Walker, remember, is because he didn't pursue Mr. Walker or try to get this information.
There's no way to pursue Mr. Walker. Is what I thought that the district court determined.
And if we were writing...
Am I wrong on that? Didn't the district court determine that it was too vast of a name? It's a common name. I thought the district court went into this at some length.
Sure, the district court absolutely decided that from a fresh slate, which it shouldn't have because of AEDPA, because the state habeas court had already made those factual determinations, and once we're not writing from a blank slate. But it's very important to remember that Mr. Prible was with Mr. Walker at the time that his trial lawyer could have found people who were going to help make this case of a ring of informants. Mr. Prible did not help his lawyers find that information at that time. He made it more difficult to find him because by the time he brought this theory to light, Mr. Walker, I guess, had been moved, but they knew each other. There are findings to support what the state habeas court concluded. That's all that matters for AEDPA.
Maybe I missed this, and so you tell me where this is. Is there a list of all the places that you think the district court's voluminous opinion contradicts findings that must be deferred to? Do you list them out somewhere and cross-reference them for us?
Maybe it'd be the most helpful if I can make just a couple, and perhaps my rebuttal time I can...
Was the answer no?
Well, I'll give an example. Off the top of my head, I think that one of the clearest things that was very concerning for the state would be, for example, ROA 8173, where the district court says that that the evidence did not show that Nila Tirado had been sexually assaulted, that the state had to prove that Mr. Prible ejaculated moments before her death. Both of those things directly contradict things that the CCA said on direct appeal. The state's evidence showed that Ms. Tirado had been sexually assaulted by Mr. Prible in a way that did not depend at all on the timing that the sex happened.
But the assistant district attorney went really hard on that in closing argument about the timing. And so I don't know that the timing is the best thing for you.
Well, the timing is, like the defense lawyer said on the relationship with the victim, it's a two-parter, was the defense lawyer's word. There's the timing, but the timing argument was largely a response to the other side's witness about, well, maybe Ms. Tirado had not spit out the semen directly before, maybe she had not, I won't go further there, but...
It would not ever last. That she said something that we now know is not true, right? The state doesn't take that position. She said it in very colorful ways, that he was different than any other man, and really kind of in that way that,
Sure, and Judge Elrod, I think we're not adding anything new to that picture because that particular line of argument had already been dealt with by the CCA. Remember, even if all of that is true, Mr. Prible's guilt is undeniable unless you also believe the story about the affair and you also believe that some unknown, unidentified person snuck into this house and killed people in 2 hours. And the case of Lucio versus Gord, I think it's in our reply brief, but it was by Justice Sotomayor when she was still on the Second Circuit. And in an analogous case where a defendant is saying, well, okay, eventually I admit that I had sex with the defendant, but someone else must have killed her. Those are the sort of...
Judge Duncan had a couple questions.
I'll
Yes.
ask you about the 72-hour note on rebuttal, but one thing I wanted to sort of ask in following up on Judge Elrod's question about deference. The claims here are procedurally defaulted. No one thinks they're not, right?
Right.
He never brought these Brady claims up. He never brought this Messiah claim up. So the question here is whether he can overcome the procedural default by cause and prejudice, right?
Right.
And there was a remand in this case, as I understand what you told me, from the CCA to the state trial court in which there was a hearing on that specific issue. Is that correct?
Yes, that is correct.
And so one part of your argument is that that is a finding, a factual finding. These Ringham informants, these factual basis was available to him. He failed to develop it. Is that not right?
Absolutely right. That's our argument.
And we should defer to that under E1 is what you're saying.
Absolutely, yes. And if I may make one concluding remark, Judge Dennis, the argument for deference to that is necessary, the argument that you were just describing is necessary in a way that stands separately from the DNA, the 72-hour note.
Yeah, I'll ask you about that later.
Okay.
Thank you, sir. Mr. Rytting? Mr. Rytting, you're a court-appointed attorney. The court wishes to thank you on behalf of the court and your client for your voluntary service. Thank you very much.
Thank you, Your Honor. May it please the court. My name is James Rytting. I have represented Ronald Jeffrey Prible for 13 years in state and federal proceedings. And I have also picked up another case, pro bono, the case of Emilio Herrera, who was also set upon by the same informants in this case. So I'm doing double duty, Judge, and so is my firm. I would like to set out a brief timeline so this court will understand the importance of the evidence in this case. And then I will address, and I would like to address, the questions that you put to respondent about the procedural issues, because I think he is completely wrong on the law and the way that cause and prejudice applies. First, this case began in April of 1999 when the victims, Steve Herrera and Nilda Tirada, were shot dead in their home. Mr. Prible was at the house, as he frequently was, because he socialized constantly with Steve Herrera. He was a family friend. His mother and father dropped him off at that house the evening before the murders. Nilda and Mr. Prible had children at the same schools, and they were seen together at school functions. And the three, Steve, Nilda, and Prible, or Jeff, went out together socially. There was a photograph of them out at the racetrack. There was never any friction between Mr. Prible and Steve Herrera, nothing known. And they planned to go in business. It was an illicit business. They planned to go into business together. And Steve was also, he even tiled the Prible household. So at the time of the murders, the state quickly developed all the evidence in this case, including the DNA evidence. And Mr. Prible did go down the very next day and gave two statements and said, I was there. And in the second statement, he admitted to having sex for the first time with Nilda Tirada. Now, people lie.
He said that only after being prompted by the investigator that his semen might have been found in or on her.
Yes, I believe that may have been the sequence of events, but one thing to remember is if he burned down the house and thought that the evidence was gone, why admit it? He came forth and said that, yes, they had a sexual affair. And we are talking about sexual behavior about which people lie constantly. The important thing to remember, and this is right here, I'd like to just make this point about the state's current argument, which goes to materiality. They're saying that there's overwhelming evidence of guilt, but they have repudiated the importance of Michael Beckham's testimony and of the DNA testimony. Those are the two pillars of the state's case heretofore. And the evidence of non-consensual sex is built or rests, as it were, on a fallacy, because the assumption is that the evidence of non-consensual sex is independent of Michael Beckham's testimony, and it is not, because he supplied the motive, and he supplied the modus of operandi. He said that Mr. Prible confessed to Nathan Foreman and to him that he killed Steve Herrera because Steve owed him $250,000 and because Steve Herrera was going to kill him. This was in a passionate, indelible speech, according to Mr. Beckham, made to Nathan Foreman, who was there every step of the way, according to Mr. Beckham, not only his trial testimony, but his pretrial statement and in deposition in the federal proceedings. Without that, you have no motive for the murders, and you have no motive for the rape. And they are ignoring that point. They are ignoring that point altogether. And that's why this case, if it didn't go cold, it was not made, even though they had all the evidence that they had by trial, except for one thing: an informant. And that is what they needed. And how did they get the informant? The next important date after the murders is July 3, 2001. And the lead prosecutor meets with Jesse Marino. And Jesse Marino tells her that my client, Emilio Herrero, has confessed to him. And not only confessed to him, but to Nathan Foreman as well. This turned out to be a lie, because Nathan Foreman wasn't on the compound in late '99 when Mr. Herrero allegedly confessed to Mr. Marino. I'll stop there. That shows, but the lead prosecutor put Mr. Marino on anyway, even though he had made this serious lie. He changed his testimony up, said someone else was there at trial. On August 8th, 2001, that's the next important date, because that is when the lead prosecutor and her investigator meet with Nathan Foreman. And he tells them, I have evidence on Mr. Herrero that he confessed, and he tells them that Mr. Prible also admitted guilt to the killing Steve and killing Nilda. And he drops the names of Rafael Dominguez and Marino, who were also informants against my client.
Every time you mention someone like Marino or Foreman or
Yes.
Dominguez, none of these people testified.
Yeah.
Only Beckham did.
Only Beckham testified. That is correct, Your Honor. That is correct. But it's going to be clear and I can make it very clear how and why his testimony would be impeached, because the lead prosecutor and the investigator came out of that meeting with Nathan Foreman, and they were convinced that he had lied to them, that he had never met Jeff Prible, in fact, that he couldn't describe him correctly. And at the end of that meeting, according to the lead investigator, Nathan Foreman said something like, well, you got to try. But he lied to them in both cases. The lead prosecutor says that Nathan Foreman not only lied then, but he also lied later on December 10, which is the next important date in this. Well, the next, I'm skipping one. On October 3 of 2001, Michael Beckham, the man who's going to testify against my client, Mr. Prible, calls the lead prosecutor and tells her that He is willing to inform on my client. And she says, you're going to have to get specifics if you want to deal with me. In deposition, in federal proceedings, he admits that they were talking about a Rule 35 reduction of sentence in exchange for soliciting information from Mr. Prible, who was already represented by counsel. He was appointed counsel on September 28, 2001.
When I hear you make those statements, the first thing I think of is, did it come out at trial that Beckham was bargaining for a Rule 35 letter?
It did, Your Honor.
So it was known.
It was known.
Did it come out at trial did it come out at trial that Foreman's name
Foreman's
spoken
name
at
did
trial?
come out at trial.
So his role in this, or at least the fact that he had a role in this, was known.
No, not the role in this. Not the role in that he actually had was not known. He was used as a witness that supposedly could corroborate Beckham. Beckham testified
Did he
that.
testify?
Yeah, Beckham testified that.
Did Foreman testify?
I mean, it was Beckham. I mean, Your Honor, Beckham testified that Foreman was there and heard the confession. All right, here is the problem that the state has. On December 10, they meet with Beckham and they meet with Foreman, and again, Foreman lies, according to Ms. Siegler. And she says it wasn't just, I thought he was, his demeanor, he was lying about the facts. They didn't fit what I knew. And he continued to lie. She also said he lied about Herrera. She never believed Mr. Foreman. So why is this important? How could it come in? I know that's troubling the court. Why would this impeach Mr. Beckham? The answer is in Kyle. And it says the standard that you use to determine materiality is what could a reasonably competent attorney do with the suppressed evidence in this case. And the suppressed evidence...
Suppressed evidence being precisely what?
The evidence that Foreman had tried to provide false testimony against Mr. Prible on October 8, 2001, and again on December 10, 2001, when Beckham was also interviewed and supplied the state with his statement.
Okay, the suppressed evidence is that Foreman was a liar and he was trying to
That's
make up
correct.
evidence against Prible.
That's correct, because his and this is the problem, and this is how an attorney would use it. What would they do on cross with Mr. Beckham? They would ask him a simple question, right? Mr. Foreman was there all the time with you. He can corroborate everything you say. Is that not correct, Mr. Beckham? And he would have no other...
Is it not correct what? That
Foreman could corroborate you. He could back you up. If Foreman was called today, he could back you up and confirm everything that you're saying. And the only answer that Beckham could get would be yes. And then what would a reasonable attorney do? He would put on Johnny Bonds. He would put on Johnny Bonds to impeach the state's witness with the fact that he couldn't corroborate Mr. Beckham and was lying to the prosecutor and to him, not only on August 8th, but on December 10th, when they went to meet. And remember, Foreman is Beckham's roommate when they met with him.
This is what would have been done at trial had they known that the prosecutor had this information that he had made up this stuff.
That is correct. And another important part of the picture is this.
And why wasn't that known at the time of the state habeas hearing?
Oh, it's only discovered through...
The timing was that, when does that timing end? We've only gotten through October 3rd, 2003, I think, on your...
Oh, on December 10th, we got through December 10th. That's when
Okay.
Siegler and her investigator meet with Mr. Foreman and with Mr. Beckham. And Foreman lies.
So what is the thing that brings it about that means that you can get into new evidence? Is it the discovery?
Oh, the discovery. Oh, it was ordered by the district court.
Right, I understand, but what the fact that it's ordered by the district court, what enables the district court to order that at that time, and that it couldn't have been reasonably discovered earlier?
Well, there's two answers to that. One, the evidence built over time. Part of the reason is because I started to represent Herrera. And no one's claiming that state habeas counsel for Mr. Prible should go represent Mr. Herrero as well. That's how I got the Herrero file. That's how I found out that Ms. Siegler had, and this is a serious point, had recommended a Rule 35 reduction of Mr. Foreman's sentence in a letter to Tracy Batson, the AUSA, even though he had lied to her in 2 capital cases. He was not assisting her. He was obstructing justice. And she wrote to a AUSA that he had provided assistance in this case. And that for his assistance, she was agreeing to write this letter. She also admits at trial that the very writing of the letter was a recommendation. And this court knows very well, I am sure, what it means to file a writing that contains material false statements with a government official. That's what happened. Now that piece of evidence also comes into evidence, and it's easy to get in. You can get it in through Tracy Batson, or you can get it in through Ms. Siegler. And then the state is faced with a situation in which Ms. Siegler has provided a reward, a recommendation of a sentence reduction for someone who has obstructed justice in her 2 cases, including Mr. Prible's case.
To go back to Judge Elrod's question, in order to have an evidentiary hearing to develop this claim with respect to, we've been talking about Foreman, with respect to any of this stuff, you have to get over 2254E2.
Correct.
Okay. Now, if Mr. Prible failed to develop the factual basis for this claim, you cannot get over E2. So I think her question is, and my question certainly is, so much of this, these people, Foreman, Walker, the Rule 35 letter, this was all known?
Absolutely not, Your Honor. Not known to Mr. Prible's attorney. And I'll explain.
That there was a Rule 35 bargaining going on between Beckham and...
Oh, they knew that, but they didn't know about
knew
the
that.
Rule
Did they know
35.
about Foreman?
They didn't know the Rule 35
They knew
about...
they knew that Beckham was bargaining for a Rule 35 letter.
That's correct.
Okay. Did they know Foreman was involved in this?
Absolutely not.
So did they ever hear Foreman's name? Was his name known to anyone?
His name came up in trial, but as a corroborating witness. They did not know that he was getting a Rule 35.
What was known about Foreman? Was Foreman known to have introduced Beckham to Prible? Was Foreman's role at all? So Foreman was known. Was that investigated? Was whether Foreman was orchestrating some sort of ring of informants, was that investigated at the time?
Level because
So why doesn't that mean there's a failure to develop the basis of the claim?
Because the representation was that Foreman was going to corroborate Mr. Beckham. And they hid the fact that he could not and that he was lying.
Well, I mean, how can they, maybe this is a naive question, but at that point, when the representation is made that they're going to corroborate, it seems like they would have a duty, they know that that's not accurate. The prosecutor knows that, don't they?
That's correct, Your Honor.
Yeah, so why don't they have some sort of duty?
Oh, they absolutely do have
That
to.
very moment in trial, I mean.
They have that moment before trial. They knew it before trial.
Before trial, but even if they say, oh, well, we didn't know this would all come out this way, and it does, don't they have a duty to go approach the judge right as soon as that Beckham says the false thing and,
But you would think so, that when he puts Mr. Foreman in the story and says basically he was there and saw everything that I did, and the prosecutor knows that Foreman is lying about Mr. Prible and about the fact that he confessed. Yeah, it seems to me you cannot even put Mr. Beckham on, right? Because you get impeached by the investigator or by the
if you think they're going to say, if he's going to say that and put that as part of his story, but certainly when he does put it as part of his story, then it's...
That you're in trial in front of a judge and telling somebody that somebody can corroborate my story, he was there all the time, and the state knows that guy's lying. That's a big problem for the state. I don't see how you can put Beckham on under the circumstances.
During the state habeas proceedings, I think it was during the state habeas proceedings, wasn't Mr. Prible trying to file pro se applications at the same time as his state habeas counsel?
That's correct.
So? And was the substance of those pro se filings about ring of informants? What was it about?
Oh, yes, there was a ring of informants, but I want...
So Prible himself was making these allegations in pro se filings at the time of the state habeas proceedings.
Yes, but the case law is clear that must guide this court's decision, as in Strickler and in Banks, where they say you do not have to, it is not required for an attorney to put on a theory for which he does not have a factual basis, that it goes against the presumption that a district attorney will fulfill her official duties.
His state habeas counsel, I believe it was Moore, knew about these things and said, I'm not going to pursue this because no one would believe it.
No, he did not know about these things.
What did he not know about?
These things are the documentary evidence that we found through federal discovery. They are the documents in the Herrero file. They are the testimony that was at deposition of the lead prosecutor, of the investigator, of Michael Beckham, and of two members of the rings that came forward, including Foreman, who said that what Michael Beckham wrote and testified to at trial was a fiction. What happened on the date that he allegedly confessed is that he was inebriated with homemade wine that was made in the prison system. And there was no confession. Mr. Foreman says that. And the judge made findings that he was credible, and that Judge Ellison made findings that he was credible in his testimony as well as Mr. Walker was credible. Now, I'd like to address the 2254 E2 question for you. It's not that as difficult as respondent has made it out to be. And the reason why is that cause and prejudice is a federal doctrine. And the rulings in state court about Section 5A have no bearing on the rulings. I'm talking about the rulings, not the findings of fact. The rulings on a hearing under 5A have no bearing, and this is the Barrientos case out of this course, on a decision to
We can
hold a
just
federal...
ignore that. The state habeas court findings on the abuse of the writ that said this would be an abuse of the writ, all this was known to him at the time. He could have developed a factual basis. We can just ignore that. You cannot ignore historical findings of fact. You can't do that. But you must make an independent determination when the state habeas court is just making rulings about, say, the availability under 5A. That's not a factual determination. That's a mixed question of law and fact, to which there is no deference is owed. So too, and it's defined in terms of reasonable diligence. That too is a mixed question of law and fact, and 2254E1 does not apply. 2250. Well, let's take, in terms of diligence, let's take Walker. The name Walker was known to state habeas counsel. Walker, who was a black man. Did he do a single thing to find out who Walker might have been?
He tried to interview and bench warranted Nathan Foreman, and he tried to interview.
Walker.
No, I'm sure Nathan Foreman. Nathan Foreman and Beckham were the only two people that he knew were involved in testifying.
He didn't know that there was a black man named Walker who had key information.
At some point, there was a rumor that there was someone named Walker who had information.
Well, did he send an investigator to Beaumont to find if there was a black man named Walker who might have had this information?
That is not how the borough prison works. What do you do? The investigator goes in there and says, "You got someone named Walker here." You can't even search. You can't even search the.
Does that mean he did nothing?
Huh?
He did nothing to find who Walker was.
Like I told you, the district court found that he took extraordinary steps to try to uncover the basis of Mr. Prible's allegation, and it's just a mere allegation, a guess that he was set up by informants that were under Siegler's control. That was a guess. is nothing but a guess. He had nothing supporting it, and there is no way for state habeas counsel to find out the information that we have developed in federal court through extensive discovery and depositions by trying to chase down someone named Walker. And there is no way, and what's very important is they say they could have known more about Walker. Well, what if he did, that Walker was, slightly chubby and had a thin mustache? How does that help you find him in the prison system? There is no evidence that he knew anything important, like, okay, this was his crime.
Prible himself said, there's a guy named Walker.
Yes, there is.
Knew him.
That's right, a guy named Walker, that's
Knew him.
it.
But
That's
Prible knew him. Prible had talked to him.
That's not true. I mean, well, what he didn't know, and as Judge Elrod has pointed out, that the person who talked to him was named Walker. People in the prison system don't even go by their last names.
And when Walker finally did testify, and I guess this is in the federal evidentiary hearing, how definitive was Walker's testimony about these matters? And did Judge Ellison make findings about, did Walker testify that Sigler was running a ring of informants?
He testified that he believed that he testified that there was a group of individuals in the prison that he knew, and there was photographic evidence of them, who were involved trying to get to and vying for to testify against both Mr. Prible and Mr. Herrero. He knew who they were, and he said Beckham was involved with these people. He was part of the ring of informants, and we know that. And Judge Ellison also found, and in these proceedings, the standard of review is you must defer to the district court's findings unless you have a firm conviction that they were wrong.
Didn't the state habeas court say that Walker's testimony was basically hearsay?
They said that it was almost entirely hearsay.
Is that not a finding?
And speculative.
Is that not a finding?
Yes, that's correct. That's the finding. But Judge,
Presumed correct under E1.
well, to the extent that you say something is hearsay is a finding rather than a determination of law, I don't know.
But is it relevant whether or not it's hearsay or not, really? Because it's not being offered that he really was confessing or whatever. It's that there's this group that he's part of a group that has a scheme going. I mean, that the scheme is going. It's not the truth of the matter. So I don't understand. When I read that, I was not convinced that's dispositive, that he wouldn't be able to offer credible testimony on the merits of the point. It's just that this thing is going on and that he knows about, that something's going on perhaps, or else he's making it up totally. All of that is helpful, even if it's completely false. And so it doesn't matter whether it's a truth of the matter.
Yeah, I mean, that's correct, but I would like to sort of correct a couple of misconceptions. There is the testimony of Walker, and originally the claim was heavily dependent on that. Then we got discovery in the federal system, and we have all sorts of documentary evidence and testimonial evidence that the claims that are presently before this court depend. And the respondent hasn't addressed the fact that we have things like a letter from Michael Beckham to the prosecutor saying, please come help me. I think I have a way to solve my Rule 35 problem, because he was worried that he wasn't going to get a big enough reduction. And this was it. I will testify against another defendant, and I'll do it with Anton Davey. And that wasn't disclosed.
Can I ask, I've got a question. In the opinion, they discuss these letters from other inmates.
Yes.
And it says that during the successive state habeas proceedings, Prible sought in-camera review of the state's files, and the state didn't oppose the motion, but didn't turn over the whole file. So does that mean that they hid the fact? I guess this is a question for the state. Did the state hide the fact that there were things not being turned over, even at the state level? So the lawyer wouldn't have known, I don't have the whole thing.
That is correct.
So it's not oh, I better go litigate fiercely to get the rest of it. It's that I don't even know that I don't have the whole thing.
Right. Yeah, that's correct. And not only that, Terry Geiser, and this is where Strickler applies, Terry Geiser, the trial attorney, filed a Brady motion, in which he asked precisely for things like statements of witnesses, where he asked for rewards and benefits, not only for the witnesses that were testifying, but for friends and associates of the witnesses.
Are we talking about the bargaining for the Rule 35 reduction? When you're talking about someone filing a request for production of documents?
We're talking about the trial attorney asking for, a Brady motion,
For
basically.
the Brady material that goes to the Rule 35 issue with respect to Beckham?
Not only it wasn't just the Rule 35 issue, but it was a range of issues, including statements made by the witness, contradictory statements, Brady, oral statements made to the prosecutor that were Brady. It was a broad Brady.
I'm going to make a representation, and you tell me if I'm wrong. It was well known and discussed at trial that Beckham was bargaining for a Rule 35 reduction. Is that true or false?
That's correct, and we haven't ever claimed that deal was not disclosed. When he testified on deposition, he said he was promised much more. He was led to believe that he might even walk out of prison when he testified at trial, and that wasn't disclosed. But the claims don't depend on this. We've never alleged that the Rule 35 of Beckham was not disclosed. That was in the trial.
If you get over the E2, let me just understand where we're going here. If you somehow get over the E2 bar, and it was okay for Judge Ellison to have this extensive discovery and evidentiary hearing, we would just rule on the merits de novo. Is that where we would be? In other words, we'd rule on the Brady claim de novo. So we'd have to find that this new evidence that was not disclosed is both exculpatory or impeaching and material under Brady. Is that where we would be?
The appellate court doesn't rule de novo, except on the findings, on the rulings of the law, but not on the findings of fact, of course. What happens with cause and prejudice is that's an independent federal state doctrine. If he finds that the evidence meets those standards, then 2254's sub-prongs don't apply, and then you can go to the merits, and you have de novo review of the merits,
which we would be reviewing.
That's exactly
So my
what
last
the court
question
said.
is so that's with respect to the informant Brady evidence. With respect to the DNA, the report, the 72-hour note from McGinnis.
Correct.
If we were to find that there's no bar to considering that new evidence, we would be reviewing the district court's decision that is Brady material and that it was both exculpatory or impeaching and material, right?
That's correct.
Okay, so answer me this. With respect to materiality of that evidence, was there any theory at trial that Mr. Prible's semen was deposited in Tirato's mouth 72 hours before she was killed? Or instead, did Prible himself testify that, well, yes, we did have sex and it was that morning?
Yes, it was right. He came out and said, yes, we had sex
that morning.
It was that morning. It was.
So how in the world could a note that said 72 hours be material?
I think for the reasons that Judge Ellison explained, because of it would have precluded the really scurrilous closing argument in which the prosecutor talked about magical semen, and that this was it could only have been seconds or moments before her death that she died.
But no one was claiming it was 72 hours before, right? At most, it was maybe 4 a.m.
No, that is correct. But it shows that this claim, this testimony testimony by the prosecutor, was absolutely unsupported, and that she.
Well, it's
knew
an
it.
argument by the prosecutor. It's not evidence. And the evidence that the prosecutor was referring to was undermined by defense expert witnesses. Is that not true?
Oh, I agree that I agree with that.
So the theory of this, the semen was deposited immediately before or immediately after was undermined by defense expert witnesses at trial.
That's correct. And Judge Ellison points out that the difference is here we have, it's a head of the crime line that Siegler goes to, finds out that she's not going to testify in her favor, and goes and gets a junior birdman named Watson, who just has a master's and has no experience, really, and puts him
I
on.
believe the head of the crime lab more than the defense expert called in, hired for that purpose.
That's correct.
The defense expert was his PhD advisor and specifically undermined his testimony and said it could have been hours.
Yes, his PhD advisor did undermine his testimony and said that.
And the jury heard that.
Yes, that's correct.
And so I'm supposed to believe that a note from the head of the crime lab that just said 72 hours survival was material enough to undermine confidence in the verdict.
No, you're not. You're not being asked to believe that, and that is not how materiality works under Kyle's. You have to look at all the evidence cumulatively. That's just part of the issue, and so you don't look at things piecemeal. You look at look at the evidence cumulatively. And here we have evidence that that the state knew that Beckham was fabricating a confession because he puts Mr. Foreman in the story, and Mr. Foreman is a liar, according to the state and the state's own investigator.
Foreman didn't testify, right?
Oh, that's correct, Honor, but I've explained how you can impeach the state's witness, and I've explained how you can impeach the state's case. That Foreman was rewarded despite his lies. He was rewarded despite obstructing justice. This shows how far the state will go to put on incriminating evidence and get incriminating evidence. It seems like it's extraordinarily difficult. And that's only part of the evidence that's in this case. There are also the phone contacts, the numerous phone contacts with the informants. Yes, Your Honor?
I'm just concerned that we're considerably over the time, but I'm not the presiding judge, so I don't, and if there's still question and answering, I just didn't know if you knew that we were considerably over the time. I wanted to make sure you knew that. And it's up to Judge Dennis, obviously, whether or not you can continue to argue, because this is a significant case, so that's.
I've let it perhaps too long. You're out of time, Mr. Rytting.
Thank you.
Thank you. Thank you for your service to the court. Mr. Cuenin, you have 6 minutes on the phone.
Thank you, Judge Dennis. I guess before I start, I know Judge Duncan, and you may have had some questions before I sat down about the 72.
Well, your E2 theory, what is your E2 theory about the 72-hour note? And are you making an argument that under E2, the 72-hour note shouldn't have been in there?
Well, I'm not making an explicit E2 argument just about the note itself, but it might be helpful to understand why I'm not making that argument. We think, in fairness, part of Williams and the cases applying E2 do have to do with things like fair notice in pursuing a claim, right? So I think the fair notice part of how much stuff there already was in the record, both about the use of informants and what was actually known or available to Mr. Prible himself, plus there is the colloquy and going through line by line with the state trial court way back at the time of trial to talk about is work product going to be turned over or not. So there's more notice there. So that's part of why we're not making a specific E2 argument on the 72-hour note, if that's helpful.
Was there, okay, they didn't have notice of the identical letters of describing the confession, right? And they didn't have that even at the time of the state hearing, right? That was discovered later in 2011, in February.
I'm sorry, I'm just thinking in my head, I want to remember the timeline accurately, because I know they were sealed in a folder. I think it was marked work product.
Right,
I
and
think
they
if they
weren't given that at the state hearing, even though they had asked for the whole file at that time.
well, but the argument about work product wasn't made until they came to Judge Ellison's court, and that
No,
could have
but
been
when
made
somebody
earlier.
asks you for the whole file and you've been representing that you have an open file policy and stuff, you need to say, well, we are holding some stuff back, but we think it's work product, so the other side can say, okay, let's go to court on that.
And I agree that's maybe a helpful way to look at it, but it cuts against Mr. Prible from the diligence standpoint.
No, because he didn't know they had that, did he? I thought he did not know they had these envelopes, even though he had specifically requested for the state hearing the entire file.
But when we're already on notice that part of the entire file is not going to include work product, you at least make the argument. And if it's not turned over at that
You
point.
would say, and any work product you have? I mean, you wouldn't specifically call out work product because they've already told you they have an open file policy.
Well-
So that there's not some that's no reason to know that there's, but I guess, so
I mean, it's always contextual, and part of the context here did include arguments about work product. Ultimately, at the end of the day, the only evidence that I heard Mr. Rytting say you could actually try to get in front of this jury, right? Because if you're talking about letters, it's not enough just to show they were arguably withheld. You still have to show what a lawyer would have done with them. There's no IATC claim here. A reasonable lawyer is Mr. Prible's lawyer. That lawyer, Mr. Geiser, said he was not going to go find witnesses who might corroborate Mike Beckham. The only thing I heard in all of the conspiracies and all of the mashing together of different cases, different testimony from 20 years after the fact, was this idea that you would ask Mr. Beckham, okay, can Mr. Foreman corroborate you? And then you would somehow call Mr. Bonds. I mean, I think that's a pretty irresponsible thing to sort of just lob out at this late stage when the trial lawyer
that he
had
was
access.
writing letters on his typewriter for other witnesses. He could have been cross-examined about that. That would have been a heyday.
And we-
Can you imagine what that would have been?
I can imagine a lot of counterfactual things about this case, but I wouldn't be concerned about them other than the things we can actually prove. So those letters, right, we don't know the dates on them. And just like Judge Higginbotham said in the Thompson case, we don't infer the existence of Brady materials. Those are undated letters that, for as far as anyone knows, post-dated the relevant conversations with Mr. Prible. If I could just make one closing point on the 72-hour note. Remember, the note itself, I think on its face said semen lives 72 hours. On its face, there's some confusion about what that means because semen, of course, does not live. It's sperm cells that live. The note had to do far more to have any real value in this case. As Judge Duncan noted, the timeline was irrelevant because no version happened within 72 hours of the crime. It was an irrelevant timeline. But the,
It is very relevant whether it happened on the edge of the killing or whether it happened several hours before. That matters tremendously in inflaming the jury and a lot of reasons of whether you get the death penalty because you're such a monster that you have sex and then have an overwhelming desire to kill. That's very, and that was ginned up to be very relevant.
I see my time has expired. May
Counsel,
I?
there was evidence.
So I would like to answer the question.
answer,
You
or-
can ask your question too, but I would like my question
sorry.
answered, please.
Judge Dennis, may I answer? The time's expired.
1 minute.
Okay, thank you. As far as what the note said, right, the note says semen lives 72 hours. Everybody at trial had already heard that the semen could have, quote, lived within the time
But
of a
they
couple of
hadn't
hours.
heard it from the crime lab head and hadn't been told that they refused to back up the prosecutor's contrary statement.
And none of that is on the face of that document, Judge Elrod. I mean, we could read into that, but that never materialized. That's not what happened. And here's what the note would have to say to make that true. The note would also have to say, semen lives 72 hours, I'd still expect to find semen in the mouth 72 hours later, and I could still extract a full male DNA profile from what I found in the mouth. It would have to do all of those things to impeach the state's witness that argument that you're talking about came as a product of, and it doesn't do that, so
I
it's
think
not.
Judge Duncan had a
Thank you, Judge Duncan.
I don't.
If there are no,
Thank
Judge
you,
Dennis?
sir. Pardon?
I thought I interrupted you.
Do we
Thank
have
you.
any ethical duties if we believe that there's unethical conduct? Do we have any ethical duties, or do we not have any ethical duties? Not certainly by
Lawyers, we all have ethical
I'm
duties.
just wondering, has that already been handled so that we don't have any ethical duties? Or, I'm just asking, what is the rule on this?
Well, just in the Brady context, right, there can be Brady violations that don't rise to a constitutional, the state must retry this person. Every prosecutor, every lawyer has duties.
I'm asking about like the bar and reporting things and that sort of thing.
Yes, that's not a part of this case. That's not, that's,
We don't have any duty to report anything we learn in this case to the bar. I'm just asking because we do sometimes have those duties, and I'm trying to figure out if we have that duty here, and not about the conduct of the state, that's not at all, or the opposing counsel here today, but about anything that's in this record.
I guess I just maybe don't understand exactly that. Everybody's got ethical duties as
Okay,
lawyers.
thank
so.
you, that's okay. Thank you very much.
Thank you, Mr. Chair. That's the end of the argument in this case. We need to have a conference. Are we going to do it on the telephone? Or can we do it on the Zoom?
Yes, sir, we can call you on that line. We'll call you on that
Okay.
line. Thank you.
We'll call on that line. In about, what, 5 minutes?
Yes, sir.
10
that'd be
minutes?
great. 5 minutes.
10 minutes? 5 minutes?
Yes, sir.
Okay,
Okay, thank you.
okay, thank you.